laws to give legal recognition to electronic records and also to make them compliant with this law's model law. So we thought we should also fall in line because we had a great stake in this world trade. So we went ahead and we started exploring how best we will implement this e-commerce model law. It's a model law on e-commerce. Then what happened when we tried to examine the legal structure of our system, we found that we have to address only 2-3 issues, major issues. We are traditionally bound to paper-based documents, where habitually we deal only with paper-based documents. Authenticity is proved with the document, its signature is there, so that is the original document. When we shift to the electronic record, we had some problems. We cannot have the same assurances which are available on a paper-based documents for an electronic record, because electronic record changes and somebody may send a transmission and he may disown it, and then he may say that it has been tampered in between. So we had to build in a lot of safeguards to ensure that the same assurances which are available for a paper-based documents or in the physical world are also available in this electronic medium. So then we thought we have to think of some equivalent, technology equivalent, and then at that time we had this digital signatures based upon public key infrastructure. Now the digital signature, whatever be the thing, initially we thought PKI was the only thing available in 2000. So we tied section 3 of the Information Technology Act with the digital signature based on PKI and asymmetric crypto system. And we said any document which is affixed by a digital signature will be an authentic electronic record, which has the same value as a paper-based record. So the first effort of ours was in enacting this legislation was to grant legal recognition to electronic records. And that we achieved through this digital signature. As far as digital signature is concerned, digital signature is a technology, it's a software. It is not a signature in the sense in which we normally understand. It is not signed with a pen. It is a software which is personal to the person, and this digital signature plays many roles in this electronic record. First of all, it ensures the identity of the signer, the person who owns that PKI. It also ensures that the authenticity of the document, anything which is changed within the record will immediately be revealed. Your signature will be shown as invalid, so the person will know. And non-repudiation, the person who sends this electronic record cannot disown it at a later stage. So these are some of the assurances which are built in. So section 3 of the IT Act grants legal recognition to PKI technology. This was criticized at that point of time, we saying that you have tied law to a particular technology and it's not technology neutral. Then at that time this was the only thing available, we did it. But right now with amendments, we are trying to make it technology neutral, and we are also looking at other types of electronic signatures like biometric tokens and other things. So our amendment which is proposed right now has moved away from PKI technology, and it's also addressing other types of electronic signatures. Then this initiative IT Act was also aimed to usher in e-governance. Now we are talking about e-governance. What is e-governance? E-governance is where people are able to deal with public utilities without having to move out of their houses or residences. For the simple reason, if you go to some place, public utility place, you have to stand in a queue to pay your license fee, your electricity bills and other things. Now all those things are now can be transacted over the internet. So you have e-governance, and you have some of the sections to deal with how to do dealings with the government agencies and public utility agencies. The most important feature of this IT Act is section 8. Now all of us are bound by laws. So many laws are being made daily. Parliament makes laws, so many notifications are issued, orders are issued. Now all these things have validity, and there is a clause which in the law which says it will come into effect from such that it is published in the official gazette. Now this official gazette is not freely available. All of us will know. Many of us, it is very difficult to get this official gazette for the simple reason it is not widely available. Now section 8, we have handled this problem by granting legal recognition to electronic gazette. So electronic gazette is where you have a website and you post everything there, and electronically where anybody can download it and you can use it. So access to orders and laws become very easy. So that is the most important feature of this IT Act section 8, which has granted legal recognition to electronic gazette. Then the other sections of the IT Act deal with conclusion of contract in electronic contracts. Now, in the Indian law of Indian Contract Act, there is nothing which requires any particular form in which you should conclude a contract. It can be even oral undertaking, acceptance is possible. But when we try to address this problem, we want to make things very clear, and we made it that even an electronic offer and acceptance will lead to a concluded contract. Then we had to put in a structure which will be in charge of overlooking this digital signature, controller of certifying authorities. And as far as the misdemeanors are concerned, there is a great demand for having more and more cyber crimes at that point of time. Now, cyber crime is a misnomer. There is no such thing as a cyber crime for the simple reason, if somebody uses a telephone for commission of a crime, it doesn't become a telephonic crime. Crime is a crime. You use various methods to achieve something. It doesn't become a telephonic crime or it is not, because the Indian Penal Code deals with human beings. Offences are conducted not by computers but by flesh and blood individuals. So you have to punish them. It is another fact that use a technology for facilitating the crime. But the computers are in a very different position. They can hold information about a crime, they can be a target of a crime, and that can, information can reside in that, it may be a repository of information relating to crime. Now, we resisted creation of more and more cyber crimes for the simple reason, as I told you, in electronic medium, information, that is electronic information, is intangible and it is ephemeral. It changes very fast. It is you have to capture the information when the offence is being conducted, which is not possible unless you conduct an online surveillance, which again intrudes into your privacy. And information, even if you capture it, will change. In criminal law, you have this doctrine known as a chain of custody. That is, from the time when some object of a crime is seized as a piece of evidence till it is produced in a court of law, you have to ensure that it has not been tampered with. It has to be taken care of. That is known as the chain of custody. As far as cybercrime is concerned, we have to freeze information. We have to search for information. Information in a network environment flees continents. It's very difficult to capture them and bring it back. And secondly, to freeze data and also to ensure before the court that the data has not been tampered with is extremely difficult, and we need a specialized expertise for that. In 2000, we did not have that expertise, computer forensics, so we did not create many offences. We kept the offences part to a bare minimum. What are these offences? We thought every type of a misbehavior in cyberspace cannot be addressed by punishing a person by sending him to jail. So we thought of an adjudicatory process where, and by process of adjudication, compensation could be paid to the person who has suffered damage. And we kept the wrongdoings, criminal part of the wrongdoings, to only three sections. Section 65, for tampering the source code, where there is a punishment, because source code, if you tamper, it causes damage. And second was hacking. In the year 2000, when the bill was before the Parliamentary Standing Committee, I Love You virus invaded the scene. And many of the members were agitated, and they said, how do you handle this I Love You type virus attacks in your bill? So we were only trying to provide civil penalties, and they said no, it has to be addressed by a criminal sanction. So 66 handles with hacking, which is patterned upon the mischief of the Indian Penal Code. Then 67 deals with electronic pornography. One of the greatest vices which permeate the entire cyberspace is pornography. Now, pornography in the physical form is subject to limitations. People are afraid of visiting pornography, books and other things because they are caught with the physical thing. But in the electronic medium, there is a privacy, and people can enjoy this in privacy without being found out. So electronic pornography is one of the greatest evils of cyberspace, and we have to handle that. So we have put another clause, punishment for electronic pornography. Then we did not make any further substantial changes except to amend the Indian Penal Code, made consequential amendments wherever paper-based documents were there. You are aware there is a chapter in the Indian Penal Code which deals with offences relating to paper-based documents. So we had to look into those things and make consequential changes so that electronic records are brought in there. For example, forgery. Forgery is electronic forgery was very different species than the paper-based forgery.